A routine trip to a grocery store or a restaurant in downtown Indy shouldn't end with a trip to the emergency room, but it happens every single day. You slip on a puddle from a leaking commercial freezer or trip over a loose mat, and suddenly your whole life is turned upside down. You're dealing with severe pain, doctor appointments, missed paychecks, and a mountain of bills. Naturally, your primary focus is on healing, but while you're recovering, there is a legal clock ticking loudly in the background. If you let that clock run out, it doesn't matter how badly you were hurt or how careless the property owner was. Your case becomes worth exactly zero. Today, we are answering the critical question: how long do you actually have to sue a store for a slip and fall injury in Indiana? Let's start with a general rule for a slip and fall Indianapolis claim. Under Indiana law, most personal injury cases are bound by a strict 2-year statute of limitations. That means you have exactly 2 years from the date of your fall to either completely settle your claim with the insurance company or officially file a lawsuit in court. In plain English, this deadline is absolute. There's no grace period, no close enough, and no do-overs. If you file a lawsuit 2 years and 1 day after your accident, the court will dismiss your case immediately. The insurance company will slam their purse strings shut and you won't be owed a single penny. Now, there is a huge exception that catches hundreds of injured Hoosiers off guard every single year. What if you don't fall inside a private big box store? What if you slipped on an icy pavement outside a public library or tripped on a badly cracked city sidewalk right here in Indianapolis? If a government entity like a city, the county, public school, or state agency owns or manages the property, the standard 2-year timeline no longer protects you. Under the Indiana Tort Claims Act, you are required to submit an official statutory written notice to the government entity, usually within 180 days of the incident occurring. That is less than 6 months. If you miss that 180-day notice window, you are permanently barred from recovering compensation, even if you are well within the 2-year limit. This is a procedural minefield, which is why talking to a local advocate early is so vital. But here is a piece of trial-tested wisdom straight from an experienced injury attorney. A legal deadline is not the same thing as good practical deadline. Waiting until your 2 years are almost up to hire a lawyer is a recipe for disaster. Unlike a car crash where a police officer writes a report right at the scene, slip and fall cases require your legal team to build a claim from scratch. And in retail environments, evidence vanishes at lightning speed. Store surveillance loops get automatically deleted or overwritten within weeks or even days. Employees who saw the liquid on the floor leave for other jobs. Memories fade, and the store will fix the hazard immediately, completely changing the scene. If you wait, you hand the store a massive head start. The store's insurance company is going to use every delay to build their primary defense, which is blaming you. They will argue that you weren't looking where you're walking, or that you were distracted by your phone. Why does this matter so much? Because Indiana uses a rule called modified comparative fault. Under this system, you can still recover compensation as long as you are not more than 51% responsible for your injuries. But your ultimate financial recovery gets reduced by your percentage of fault. But if the insurance adjusters can twist your words or exploit a lack of physical evidence to find you more than 50% at fault, you walk away with nothing. Surviving a severe slip and fall is painful enough without trying to navigate complex civil litigation deadlines and tricky insurance adjusters on your own. Let us carry the legal burden so you can focus entirely on your physical recovery. If you or a loved one have been hurt in a slip and fall in Indiana, give me and my team a call here at the Mark Lopez Law Firm. We would love to talk to you about your options. The number is 317-632-3642. And remember, insurance companies are not your friend, but I can be. Give me a call.